What's up, everybody, and welcome back. More Sarah Boone news. And since our video yesterday, even more stuff has come out. James Owens, her attorney, has done more interviews, giving us more information. We've got some information from the notes from the jail about some interactions between her and her lawyer, which we'll discuss. There are also 4 different motions we're going to read and discuss together. What is he looking for? What does this tell us about what they're going to argue? What do we think they're going to get out of this? What angles are criminal defense attorneys thinking when they file these motions? We're going to talk about all that and more. And of course, we're going to answer all your questions. As long as you hit the like button and subscribe to our page, let's get into it. So we're going to start with the interview he did on Court TV. And I thought it was interesting that this is where he said he saw the ad for the wanted ad for a lawyer from Sarah Boone was on Court TV. So we're going to watch this interview here first. Then we're going to watch the interview he gave outside the courthouse steps after his first motion hearing from yesterday. And then we're going to read through the motions that he filed and, of course, get to some info that I think it's better to watch these interviews first as it gives context to some of the comments we're going to read later. And actually what I'll probably do is weave them in as we watch these videos to show you what I think they mean. And it does have to do with Manley's comment here. So I'll just leave this up on the screen for a second so you know what's coming later. We're going to discuss this, but let's take a listen to this video.
Step forward to take this case. Yes, an attorney in Florida. Joining me by phone, Sarah Boone's ninth attorney, James Owens. James, thanks so much for joining us tonight.
Thanks, Vinny, for having me.
Okay, the first question, I know everyone's asking you, why? Why did you take this case, James?
Well, I watch a lot of YouTube, and I watch a lot of Court TV, and I've been following this case, just like all the other true crime people do, and, kept...
Isn't that interesting? He watches a lot of YouTube. He watches a lot of Court TV. He's a true crime fan as a criminal defense attorney and a legitimate criminal defense attorney, an elected public defender at one point. I found that to be very, very interesting.
Kept watching it being delayed and the lawyers being switched and switched and switched, and then saw that the judge got fed up and ruled that she had forfeited her right to a court-appointed counsel. And so that's a rare event. As lawyers, we know that everybody has a right to a lawyer, a court-appointed lawyer, if you can't afford one. So on a serious charge, a felony, in this case it was a murder, for the judge to revoke that right was a serious decision on his part. I don't disagree. I respect the court's decision, but that left her facing a murder charge.
He said he doesn't disagree. I know he said all along that he respects the court's opinion, but he doesn't disagree. I found that to be an interesting comment.
A lawyer, which is unheard of, I think. And so, I watched for a while, and then I saw the ad on your show. And I think that you had said something implying, hey, who's gonna take the case? What lawyer in Florida is going to pick up the torch, so to speak? And I think you had somebody on, maybe it was a lawyer from the Northeast, and I think I remember that lawyer saying, man, if I was a license in Florida, I'd take the case, under that scenario, because she really needs a lawyer. Everybody needs a lawyer. And so the ad came out, and I sat there and waited for 3 or 4 weeks. I can't remember now how long I waited, but I was thinking that a lawyer out of Orlando would pick up the case. Somebody would think, hey, this is not right. There's no way she's going to get a fair trial, represent herself. It's unfair. But there's a gap in the system. The judge made a decision based on her conduct that she had forfeited a right to a lawyer. I believe that's where the private sector has got to step in. Somebody in the private sector in that situation, and it's rare, should step in. So I waited. Nobody responded in the local area. So I just happened to have a case down in Hillsborough County that I was going to.
So I have thoughts on some of the comments he's making, especially where somebody needs to take up the torch. Nobody stepped up in the local area. We're going to talk about that later. I've got some thoughts.
Down in Tampa. And so I knew I was scheduled for court down there. So about a week before that, I sent her a letter, and she had a third party contact me to, check me out to see if I was legitimate. And
well, I think everyone's been checking you out in the last couple of days, and everybody knows you are absolutely legitimate, James. I mean, you have quite a history.
I've been doing it a long time. I've been doing it a long time. So anyway, she reached out to me, and then a couple of days later, Sarah called me from the jail in Orange County, in Orlando. And we talked for a little bit, and I explained to her that I was coming down that Wednesday, but I'd come down early and spend Tuesday talking to her, and she agreed. So I drove down Monday after work.
Well, describe that meeting without, I know attorney-client communications is off limits, but how would you describe that meeting to someone? Like, was it different than meeting other clients for the first time?
The first meeting?
Yeah.
No, it was a 4-hour meeting. I usually don't meet with clients in the jail for that long. So I gave her a chance to talk and just listened.
4-hour meeting. He doesn't usually meet with clients in the jail for that long. I tend to think the initial meeting is for a very long time. And I wish I would have done this beforehand. I didn't, but I believe the comment earlier that Manley had on the screen was there was some sort of shouting match. I believe that was on August 26th. Let me see what day of the week that is, because he's talking about Tuesday. He's got that kind of Southern draw. What was August 26th? Was a Monday. So I don't know if this was the day he met with her for 4 hours or if it was the Tuesday, which would be August 27th. Either way, there are reports from the jail that they made such a disturbance, James Owens and Sarah Boone, that somebody had to go and tell them to chill because it was a disturbance. And James Owens is like, no big deal. We just got in a disagreement. Everything is fine. So they're screaming at each other enough for somebody to have to come make sure everything's okay while they're meeting at the jail. And this is before he becomes her lawyer. So let's remember that when we get more context about how this attorney-client relationship developed.
For a long time, she had a lot to say. Obviously, she's been in jail for 4 years. And, we had a good meeting. Just, again, I think she has trust issues because she felt like she did have some good lawyers that were on her case and just withdrew because they would get in some arguments about issues, I guess. And so she said
they would get in some arguments about issues, kind of like a disagreement that maybe got a little loud at the jail between these two.
Even tell her anything at the jail, but the next thing you know, she would, be sent to court and the lawyer had filed a motion to withdraw. So she didn't, trust the lawyers because she didn't know who to trust. She'd been with so many. So a lot of it was just trying to build trust with her. After she talked a little bit, I told her a little bit about myself. So really feeling each other out and trying to build some kind of rapport was the first meeting, which was about 4 hours. But I think early on in the case, I was able to persuade her that I knew what I was talking about because I was prepared. When I got there, I was prepared and I played.
So he had to persuade her that he knew what he was talking about, which I found was, again, these choice of words. And again, I'm a lawyer. Maybe I'm nitpicking a little too much on the words, but imagine that. You go into Sarah Boone, you have to persuade her you know what you're talking about. There's a screaming match at some point, and he pulls another tactic that I found to be important, and we have done it as well. A lot of criminal defense attorneys do it. I'll tell you why we do it. And again, this timeline and taking the parts of his different interviews and the court filings and kind of knowing what's happening all at this time is going to help us put the pieces together to this picture.
Part of that 4 hours, I played the prosecutor and I pulled out prepared. When I got there, I was
here. It is. This is the part I'm talking about, the tactic we use sometimes as criminal defense attorneys.
Prepared, and I played part of that 4 hours. I played the prosecutor and I pulled out the jury instructions and I made an argument as a prosecutor would make to a jury. And I had her sit there and listen to it. And I think that was effective. I don't think
he played prosecutor. He pulled out the jury instructions and explained the case about, or from the point of view of a prosecutor, meaning he explained to her how bad this case can look and sound if a prosecutor can argue in court, which is going to happen to you, Ms. Boone. And we have to remember when this was. Initial meeting, 4 hours prior to him representing her.
She had anybody ever do that to her and explain it to her that way of how it would play out in court. And that got her attention. And
she never had anybody do that before, never explain it to her and how it's going to come out in court. That got her attention.
Initially I was going down there. Let me tell you, my initial thought going down there was this. She didn't have a lawyer. And once that happens, once they're pro se, then you know as well as I do that all these cases are up for negotiation. Plea agreements are pretty much on the table at any time, and judges recommend, the courts recommend, you try to work cases out. The vast majority of cases get worked out with pleas. So, I talked to her about that, and that was my intent. I'd called the prosecutor and told him I was coming down there to speak with her ahead of time, and he wanted me to file some kind of a notice of appearance, and I didn't want to do that. I wasn't ready to take on the case. So I got her to sign a document.
So he goes and he meets there multiple times, doesn't want to take on the case, doesn't file a notice of appearance, which again is interesting when we start to talk about his other comments later in his other interview.
Essentially saying, hey, I don't want to negotiate directly with you, state attorney. I would like for James Owens to work, just to talk to you. And so she signed that, and I did, for a couple of days, talk to the prosecutor. I was trying to resolve it.
Right.
And it felt like...
So then he talks about how he's trying to resolve the case. He's playing mediator between prosecutor and Sarah Boone. She signed something that said he could negotiate this plea deal on her behalf. So it's no surprise, working on a plea deal again, that stuff happens. But let's remember the context we have now. We have context that in their first meeting and maybe subsequent meeting, depending on the dates and how it lines up, was multiple hours. And at some point, he was playing prosecutor, explaining this case to her. So why do defense lawyers do that? We do that so a defendant can understand how bad it is, how bad it could be, how bad it will or could sound at trial. A lot of us were prosecutors before we were criminal defense attorneys, right? 3 in this office, including myself, prosecuted cases before we defended cases. So we explain that to a client to get them to understand, like, you should consider this plea deal. It might go bad at trial. So we have the context of him playing prosecutor. Then in the very next breath, he says he was trying to negotiate a plea deal. So what does he think? Does he think she should have taken a plea deal? And none of this is going to get held against her at trial. I just found it very interesting. Didn't want to take on the case. Even after meeting with her for 4 hours, maybe there was some kind of screaming match. What is the first thing he tries to do is work it out in the plea deal without ever having to come on the case. Work it out with a plea deal. Was she not happy about that? Was she not happy about him playing prosecutor? What was the screaming match about? We may never know. But the context we have is a very step-by-step process. Meets with her 4 hours, doesn't want to take the case, starts negotiating a plea deal, then ends up taking the case, and we'll listen to how it gets there.
I felt like the judge is 6.5 a trial, a 3-week trial with a pro se defendant, prosecutor 6.5 a trial with a 3-week trial with a pro se defendant. It was not going to be fair. And I felt like they might be in a posture to try to negotiate something that would be doable. So that was my first intent, was not to handle the case, not to try the case. If we got something worked out, then I would file a notice of appearance and we'd set it for a court date to resolve it.
That didn't happen,
was my first. No, it didn't. And, I left that 4-hour meeting. I went to Tampa the next day, had court, and then turns out the investigator that had been assigned to the pro se litigant, Sarah Boone, he was meeting with her that evening at 7. So I asked if I could just join. So I came back over and spent about an hour and a half with her and Billy Lane, the investigator. And we talked some more, and I was convinced that there was going to be no plea bargaining. So I told her I was not representing her and I was leaving. And I emailed the prosecutor or called the prosecutor and said, look, we've reached an impasse. There's no agreement and I'm not going to be representing her. And I went home. And I want to say a couple of days later, Sarah called me and we talked some more. And I told her Vinny,
So, but at this point, she's now reaching out to you because she wants James Owens to represent her.
Well, we did connect. We did connect. And I think she was overwhelmed being her own lawyer. She was stressed out.
Yeah.
She had
as anybody would be,
all this discovery that she was trying to go over. She didn't know what she was doing. She didn't know the rules of procedure, rules of evidence. And she had told the judge, I think they'd had a couple of hearings on some issues. And she said, Judge, this is not fair. I don't know what I'm doing. And the judge kept saying, well, I'm sorry, ma'am, but this is your position. So I think she was just thankful that I came down to see her. We had, some good meetings. So I think she really needed some help. So I think that was partly to do with it, but there were still some issues because she was let down because I said I wasn't going to represent her.
Right.
So we got off the phone. I still said I wasn't committed to it, but I was thinking about it. But as you know, second-degree murder trial, and the judge had set a firm date for October the 7th, which is really difficult to do. I mean, you pretty much have to shut down.
So again, he knows at the time that this is October 7th, and the judge has set a firm date, aka a date certain, we like to say in the law. So he knew all this, and that's one of the reasons he wasn't going to take the case, but then he ends up taking the case. So the judge was right. You knew what you were getting into to a certain point. Terry, as a defense lawyer, it cannot be easy to persuade. Hold on a second. It cannot be easy to persuade your client to take sage advice, even when they feel wronged by prior lawyers. Building rapport is about trust, but it has to be reasonable, right? Thanks from England. Yes, absolutely agree with this comment. Has to be reasonable. You have to build rapport. That's why the private lawyer-client relationship usually works better than a public defender. I shouldn't say usually. Some of the time works better than it does the public defender because you choose to work with each other. Like Boone and Owens eventually chose to work with each other. So it's like we both are choosing to be here. And as long as we continue to choose to work together, public defenders sometimes feel forced to. Client doesn't want it because they didn't choose their lawyer. Even if it's a good public defender, sometimes clients feel that way. Peter, is he allowed to quit if they can't get along like the others? Art and Grace asked. So the answer is maybe. He can try to quit. He can file a motion to withdraw. The judge does not have to let him withdraw. And I will tell you this right now, as unfair as that may seem, we defense attorneys, we know that that's a possibility. This guy, James Owens, knows if 3 weeks from now there's a big blow up and he tries to withdraw, that the judge might say, no, you have to represent her now. You've got to show up for this trial. He knows that's a possibility, not a guarantee, but they don't let us, not that we'd want to screw our clients, okay? But I'm saying you can understand. If a defense attorney bails the week or 2 weeks or a day before trial and the judge doesn't want to continue the case, the client's screwed. So there's 2 options. Continue the case. 3 options. Continue the case, force the client to go pro se in 1 day or find a lawyer in 1 day to handle the case, which is almost impossible, or force the lawyer to try the case. So he knows that this is a possibility and he's deciding to take the case regardless.
Down your practice for 30 days or 6 weeks.
Absolutely.
And just to try to catch up and just be, which is essentially what I'm having to do. Now,
well, you've seen the body cam, all the interrogation videos, the 911 call, and then of course the cell video. It starts there, right? But in terms of getting prepared in 30 days for this trial, that's 4 years old, and a lot of things have happened. Can you do it? And will you be ready?
Well, I'm gonna do my best with the time I've got left. That's all I can do. I'm gonna get some help. I've got to get some staff helping me. I've got a couple of lawyers that are buddies of mine that have offered their help. So.
I should send that lawyer from the Northeast down to help you. Joseph Krowski is the guy.
Yeah.
We'll let him know that he's the reason that you jumped in the case. He may fly down there to help you. He's up in Boston. It's cold. He may come down and help you.
Yeah, that'd be great. And I've got 2 lawyers that, like I say, I think are going to help me. I'm pretty much committed to it. They're friends of mine, and I trust them, and they want to help me. And they realize I thought the case was going to be continued. I respect the judge's decision, but I really.
It's not just him, but 2 other lawyers are going to help him. That's interesting too. Are they getting paid? How's all that working? He also says now he really expected the judge to continue the case, to continue the trial.
Let me ask you.
I thought the case was going to be continued. I respect the judge's decision, but I really thought.
Let me ask you this. Have you spoken to any of the other 8?
Yes. I spoke to Ms. Cashman, who was the last lawyer that had it. I've tried to speak to Mr. Padilla out of Miami. He's the one that had the case initially. He had it for about 2 years, maybe 2.5 years. He did most of the discovery, took most of the depositions. I think they were pretty much ready for trial or getting close, and he withdrew. But I've tried to call him a couple of times. I know he's been in a double homicide case he just got out of, but I never was able to speak with him.
And you're doing this pro bono? I don't think she has much.
No.
What are you getting?
So he says no. So it's expected pro bono. We heard that in the hearing. He says no.
Well, Sarah's got to pay me back one day.
Okay.
Sarah's got to pay me back one day. Okay. That's never a comment you want to hear or say as a criminal defense attorney, that the client will pay me back one day. Most criminal cases are done either hourly or all upfront on a retainer or some kind of payment, right? So you just pay it all upfront. You get it all upfront because if you lose, they're in prison. If you win and they don't pay you, it's a messy situation afterwards. So either hourly and all of it has to be paid before trial with some kind of trial fee, retainer agreement where they pay it all up front. That's the most common way. That's the way we always do it. 99% of our criminal cases are retainer all up front, besides the trial fee, which has to be paid, a couple weeks before trial. That's how most people do it. Some lawyers do have payment plans hourly. They're chasing clients. It is not fun. I've talked to lots of criminal defense attorneys that do this. They wish they never did. I'm not saying that's what he does with all of his clients. I'm just saying something like, she's going to pay me one day in criminal law. That's unlikely, I'll just say. Now, if he wins and there's a big book deal or something like that, movie deal, sure, he'll get paid. But the likelihood of somebody getting paid later is not high.
Okay.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me. It's important to them, that some of them only pay $50 for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month.
He's got a bunch of clients paying him. Some of them only pay $50 a month. I mean, every lawyer does things differently. That was not a Freudian cough, by the way. Something just cat got my tongue. But I don't understand how a lawyer makes it work on $50 a month for some clients. I don't understand. Maybe he's got a couple big clients. I don't know. But we are going to discuss this more when we get to his next interview about why it's important to discuss and think about your paying clients in a moment like this.
And but it's important to me. It's important to them, that we have an arrangement to make payments, and that's what I told her.
Do you think?
I feel.
Do you think she needs to tell her story in the courtroom?
Well, Sarah's a unique individual.
Does she need to tell her story in the courtroom? A very long pause. And he says, Sarah's a unique individual. That's how he starts this answer.
I don't know. In a criminal case, it's the time to tell her whole story. I think if it's necessary, she'll take the stand. We're just going to see how the case plays out.
Ended up being a really good answer, but he had to kind of pause and think about it. He said, I don't necessarily know that a criminal trial is the time to tell your story, and I agree with him. And then he said the other perfect answer as a criminal defense attorney. If she needs to take the stand, she will. We'll make that decision when the time comes. I respect that. I think that's the perfect answer.
We'll make that decision when the time comes. Of course, she's got a lot to say. She's filed a lot of pleadings, a lot of letters.
We've seen them. Trust me, we see. So James, this is what I want to do. I want to stay in contact with you, and we are legitimately going to reach out to Joseph Krowski to see if he is willing to get down there if he needs an extra hand. But also wanted to let you know that I wanted to let you go now because I know you've got some discovery. You got a couple more hours tonight. You can jump in there and as you get ready for this. But I hope that we can reach out to you as we get closer and closer to the trial and grab a couple minutes of your time.
Thanks, Vinny. Appreciate you.
All right. So that's it from this interview. We are going to pull up his other interview because there's a lot more in there. Factual Lie said, tagged you on X. Hannah Gutierrez took a plea. Reed took a plea. I saw that. And we'll talk about that probably in another video. I really like this lawyer. He gave Sarah the reality check she sorely needed. This is so interesting, and even more to come. Watching while studying for my digital court reporting classes. Hope y'all have a good day. That's awesome, Michael. Good luck in your classes. Do you win most of your cases, Peter? So in the criminal world, it's like you win some, you lose some. What's considered a win, right? Even if you lose, but it's a lesser charge. Or if you take a plea deal and somebody goes to jail, is that a win? Is that a loss? It's different in every case. We've won some trials. We've lost a lot of trials. Usually you have an uphill battle when you try a case, especially in federal court. And we do federal work as well. I don't do as much criminal defense work as I used to at all. Probably the last 5 years, I haven't done much. But the first 6 years of my career, I did a lot of it. As far as the civil side, yes, absolutely. The answer is yes to this. We've actually, personally, knock on wood, never lost a car accident trial, or, any civil state court trial that I've done. And then the vast majority of cases end in settlements that our clients are good with and sign off on. So I take that as a win if the client's happy at the end of the day. I think he's super confident he'll be paid, but he's got it set up with Sarah Boone. Ever earns money at some point, he'll get his cut as he deserves, Daybreak said. I mean, he is not confident he'll be paid. I was going to say, I don't know where you're getting the confidence in him getting paid, but, to each their own, right? Everybody is entitled to their own opinion. And now we are going to get to the video that was outside the courthouse after the hearing yesterday. And this is the one I really wanted to kind of dig into a little bit more.
Thank you. Excuse me? Why this case? Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration. Okay, this just a gap in the system that hardly ever happens. At the federal level, on the state level, everybody charged with a crime is entitled to counsel. Everybody, never unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling. But that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime. I saw it. I didn't immediately act on it. I waited 3 or 4 weeks thinking that.
By the way, congrats. We love YouTube true crime watchers, right? He's one of us, basically, which is cool. And we talked about it in the last one. But here we go. Now he's going to get into the fact that.
One of the members of the.
So he saw this. It got on court TV somehow. I wonder how. And then this is what he did. This is what he was thinking.
4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen. I had another case down here in Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that. And she had a third party, a girl from Minnesota, that reached out to me, I think first just to see if I was legitimate. They said to see if I would, I think catfishing is what they thought I was doing, somehow, some fraud. I think once the third party realized that I was genuine, then Sarah called me. And we talked on the phone a couple of times, and I said, hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think, Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th. And I spent about 4 hours with Sarah Boone at the Orange.
All right. So if it was the 20th, he spent the 4 hours. I think the 26th was a screaming match. So those would have been separate days. I boosted the audio as much as I can. So I'll let you know if you need to adjust the audio when I come on or whatever, but we're going to listen to him talk here for a second. So here's what I'll do. I'll go ahead and give some of my loudest thoughts in my mind when I listen to stuff like, I thought somebody from the Orlando bar or local bar would take up the torch here and represent Sarah Boone. So I get it. I hear everybody saying that I'm loud and you come on. So here's what I'm going to do. I'm going to give my thoughts here. Then we're going to listen to the rest of the interview. Then I'll give more thoughts so we can deal with it all. But I have it boosted as much as I can. So my thoughts on why didn't somebody else pick up this case? Peter, why didn't you pick up this case? I had that question plenty. No problem. I welcome all questions. I've answered it a million times. Happy to answer it a million more. But let me just tell you the thoughts of how this works. Sarah Boone is not the only unrepresented person in Florida or in the United States. She's not the only person who feels like a public defender or court-appointed lawyer is not doing their job. She's not the only one that feels unrepresented, even if she may be unrepresented. Okay? So that's the first thought. It's not just Sarah Boone. There are a lot of people that really, really need lawyers. And I wish every single person could have a lawyer. I think that is the best way to go through the process. I think nobody should have to represent themselves. As he said, it's foolish. I completely agree with him 100%. I think he would agree with everything I'm about to say, by the way. But I just don't want anybody to get, confused or twisted or whatever with what he's saying here, that shame on those lawyers for not picking up the case. Because I think there's a tinge of that, but I don't think that's what he meant. And let me tell you why. So it is important. I want everybody to have a lawyer. Absolutely. I wish I could help every single person. I think you guys know that. I mean, YouTube's kind of cool because I can literally tell thousands of people about their legal rights, explain the legal system that I would never be able to do in just my normal life and people that I meet. So that's really cool, but I can't represent everybody, right? No lawyer can represent anybody. So why is that? And can we change that? And my first two and main most important points would be, I have made very serious commitments to two groups of people, as a lot of lawyers, not all lawyers, but most lawyers have done, right? That have their own firm and their own private practice. Number one, the people I'm committed to most will be my family, my wife, my kids, even my close friends, loved ones, right? And what is that commitment? Why does that affect this? Because if I tried to take every single case of a person that didn't have a lawyer, or everybody I thought had a legitimate need, or everybody I thought I felt for and really wanted to help and felt like their rights were getting stepped on and I need to step in and do something. If I took every one of those cases, there's no way I'd be able to keep the commitment of being a good husband, dad, friend, loved one, family member. Okay. And that's important. It's important to me. It's important to a lot of people, and people can, whatever, they can poo-poo that, as I say, but it's legitimate. That's a legitimate thing. And for lawyers and anybody else with professions, doctors, whatever, anybody that helps somebody or is in a service industry of some sort, you want to help more people, you want to serve more people, but you can literally make yourself go crazy and work yourself to the bone and not have any real life outside of work if you do something like that. And I don't think that's healthy. I don't think that's a good point. Number two, he mentioned it, paying clients. Paying clients are a very important group of people when it comes to this, for this lawyer, for me, for every other lawyer that would even consider thinking about this case. Because you're paying clients that you've agreed to represent, that are paying you, have to take precedent over somebody else that asks you to do them a favor, right? How is that fair? How is that just? How do you explain that to somebody? Now, sometimes if you were going to do something like this, maybe you talk to your clients, they understand, all hands on deck for 30 days, but not a lot of work is going to be getting done in those 30 days. Your staff, everybody else has to pile on, work more, work harder when a trial like this pops up. Okay? So from my perspective, there are two very important groups of people to me, my clients and my family. And they're the ones I already have relationships with, especially the clients. You've already agreed to take their case. You're already working on their case. You can't just not work on it for a month. And he mentions that. And that's what makes it so hard. And that's why he was asking for a continuance. Okay. So I just want to make sure that was clear from my perspective. And for a lot of lawyers, that it's not that, oh, we don't want to help people or we don't care about people. It's like there are very important commitments and relationships that we make. And there's a lot of giving back, right? Part of organizations and groups and philanthropy and charitable organizations and whatever it may be that a lot of lawyers and other professionals do, that would be cut into in these situations as well, right? So everybody balances. It's not like a lawyer, all these lawyers are sitting on their butt and not, doing anything, and they just don't want to help people. So I felt it important. I felt compelled to tell you that. So I just want to make sure that perspective is laid out, as well as, take up the torch. And it is important. We do need to fight for people's rights. We do need to help people understand their rights and make sure they're not trampled on. Okay. So I did want to say that. I'm going to throw some questions up here. I wonder if he will set up a site for donations to go directly toward her legal fees for her fans to help her out. Maybe. I don't know. That's absolutely possible in today's day and age. Dang, this chat is moving faster than Sarah switching attorneys. Don't forget to subscribe. Yes, thank you, Olga. Everybody hit the like button and subscribe, please, if you're here, because this thing's going fast and furious. We got a month until trial. So, okay, now I'm going to put this back on. You guys can turn it up. I will try not to interrupt too much. There's 9 minutes left. We'll watch the 9 minutes, then we'll talk, then we'll get into the motions and more of your questions.
Orange County Jail. During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed a notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts, like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it. So there were attempts to settle it. I was kind of like a mediator. I was kind of like a go-between, because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it. But after those, so I met with her that day. I went over to Tampa, handled my case. I think I was done at 2:30. I came back. Well, Billy Lane, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with them. So the three of us met. This was, I think, the 21st. From 7 to 8:30, we met for about an hour and a half. And, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8:30. I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home, and Sarah called, and we talked again. Of course, I was still thinking about it, what to do, and but I told Sarah I was not committed to doing it. That was on like the 23rd. Within that third party called a day or two later, and really nice lady that I really respect. We developed a relationship, and she asked me if I would go one more time. So I flew back down. We met again a couple of times. I can't remember the dates now, 25th and 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And on both sides, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But, I like her. She likes me. We communicate well. I think we're both on the same page. And, I spoke to my family, my wife, my daughter Sarah about it. Sarah's thinking about law school, so I got their blessing. I have, some colleagues that I practice law with, a law group there in Milton. And obviously it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help from the staff, but we're trying to assemble a team right now. I've got a couple of friends that are lawyers that have indicated they're going to help me. And what are friends for?
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
Who's paying for it?
Sarah owes me. Sarah owes me.
Can you speak a little more to your plan for defense about the battered spouse visit?
Well, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think y'all understand the rule now.
I'm not speaking very loudly, but the battered spouse syndrome was the question. And he said, I don't know that we're going to have time to do that. I have more comments. I'm taking notes. We'll talk about it after, but that was very important in case you couldn't hear the question.
We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The 2 experts that I had asked for, well, there's a 3rd one, but 2 of them are from my area. Dr. Harper's from Okaloosa County and Dr. Berkman's from Escambia County. But I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so then if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense. And then we go from there. That's really all I can say. It's up to Dr. Harper, not me.
You've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, you know, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. You know, I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations. I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. You know, just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens in this week. It'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres's prior arrest. I did want to say something else, but I want to.
So here's another thing, very important. He made sure he was going to have time to say this at the end of his interview. So this is something he's going to, blast out of left field here. And then we're going to talk.
Let's say something, but I'll wait for you. If you
We
got
gotta move downstairs.
Okay.
Or, I mean, we can just wrap it up.
We can just wrap it up.
I did want to say this. The Torres brothers are violent towards women. I'll say that again. The Torres brothers, George and Farrell Torres, are violent towards their women. Farrell Torres is George's brother. Are y'all aware of this? He was arrested in May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here. He called 911. Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction. I seriously doubt that's going to be admissible in my trial.
Agreed.
But there's two sides to every story. And Sarah's got a story to tell. I think she's been mistreated to some degree. It's difficult to represent yourself. I wish you could just imagine if you had a daughter that was in her situation where she's representing herself, or maybe a sister. Just for 10 minutes, just think about her situation. You know, she's backed into a corner. She's the type, like most of us are, they're going to come out swinging. That's what she's been doing. Some of it is probably appropriate. Some of it has been inappropriate. But it's all she knew to do was to fight. And she's been fighting. She didn't have to fight anymore. I'm going to do the fighting for her. So she feels good about it. I feel good about it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying.
Adjust your levels here. Okay. So a lot going on there in that interview. I'm of course going to answer the questions you guys have, but a lot of you are saying, oh, he's got time to do interviews, right? Why doesn't he go and, start, go ahead and start working on the case or going through discovery, et cetera, et cetera. And then he comes with, something he was obviously saving and wanted to say it on the cameras into the microphone for everybody to hear. The Torres brothers are violent towards their women. And he says one of them, not George, but his brother, was arrested in May for hurting his spouse or ending her life. Okay. So number one, even he admits that ain't going to be admissible in this case. What somebody's spouse does to show some kind of tendency or preponderance for you to do, or propensity, I should say, for you to do something is not a thing. You cannot do that in court. There's a million reasons for it. What else I find interesting is he's been arrested for that, not convicted. So he and Sarah Boone basically sit in jail the same, accused of a violent crime against their significant other and presumed innocent as they sit there. So I found that to be interesting. But it was very clear what he is doing and wants to do. And some people can say, he just wants fame, or he's doing this case for the clout or for the publicity or whatever. Okay, I don't know. I don't know his motivation. I don't know the heart behind it. But I will tell you, we know Sarah Boone has felt like the media has been totally unfair. I think we can all agree. The media has not been positive towards Sarah Boone. It's been negative, generally. I hope we have not been negative towards her. I've tried to be fair, call balls and strikes. Some things have been horrible. Even he said some things she's argued are appropriate, and some things she's argued and done are inappropriate. I think anybody looking at this objectively would say that. Maybe not Sarah Boone, but she's also probably not looking at it objectively, since it's her own case in her own life. Okay? So, but what's he doing here with these interviews? Publicity chasing, or what a lot of good criminal defense attorneys do. And that's, hey, all the media has been negative towards you. There's no gag order. You're allowed to talk about the case. Is he trying to change the narrative, or at least put some questions in people's mind? Because while it's not going to come out in trial, and he knew it wasn't going to come out in trial, why would he want to say it in this interview? I think he wants to say it in this interview so maybe some people out there in the world and the public and the media, maybe potential jurors, are like, well, hold on. Is the victim in this case dangerous like his brother? We know that they're going to go try and get more discovery and more witnesses to testify to the altercations and domestic violence between George and Sarah. And maybe he's just trying to flip the narrative in the media, or create a different narrative than is being used. That could backfire. Victim blaming. If it's the brother and not him, why are you saying it? You're clearly trying to paint him in the same point as the brother. It could backfire. But I think it's pretty clear that's what he's trying to do there, is create a different narrative, change the narrative, have people looking, maybe talking about somebody else, not make Sarah the bad guy. It's what it felt like to me at the end, for sure. Diva Dawn said, personally, I think he sees her as being his Casey Anthony. Fan lady said, victim blaming incoming. Luis said, didn't he say he was pro bono in court? I can't remember if he said it or if it was in a motion, but I'm pretty sure that's what came out to the judge. And here's what I'll say. A couple different things with that. Number one, if she ain't really paying you and you're like, maybe she'll pay me later, it's pretty much pro bono. But technically, you're not allowed to do that. It has to be like actual pro bono. If you say it's pro bono, if you claim the hours as pro bono, you can't get paid, or maybe I'll get paid later and call it pro bono now. But payment relationships can also change. He could be pro bono when he files a certain motion, and then she could say, okay, now actually I can pay you. So that type of stuff can change. I'm going to leave it up, for interpretation at this point. I don't know the answer. Peter, the case with the 13-year-old Madeline Soto, whose mom's boyfriend hurt her, was in my son's class in Orlando. I chaperoned with the mom. Would you consider the case? I know it's dark. So this is interesting. I don't know when we're going to do some kind of announcement or tease for something that's coming mid-September. September 16th is the week that something new and cool is kind of dropping here, but we considered this case for that. And the people I was working on this with were like, it's just too brutal. So right now it's on the back burner. I haven't really looked into it much, but I've heard it's so brutal and dark that I haven't looked at it much yet. I wouldn't say it's completely off, but it's not on the front lines at this point. Okay. So now that we've gotten through his interviews, let's take a look at what he's done. Let's take a look at some of these motions. Some of them are quick. Some of them will take a little more time on. Some of them you guys had a lot of questions about. Let's start with the motion for additional discovery. Comes now defendant and requests this court for additional discovery, and as grounds alleges. Under 3.220F, additional discovery on a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide the written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures. In particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office. So what could he be using this for? Let's try to think as a lawyer. Why does he want this? very clear. Did they violate any policies or procedures that they have for themselves? Did they violate any constitutional, any laws, statutes, the Constitution, anything like that, any of the rights of Sarah Boone? If they did, he's going to try to get some of those statements thrown out, maybe the entirety if there was some policy and procedure they screwed up. He needs those policy and procedures. What's a problem is he's not going to have time to depose all these cops again. I assume they've been deposed in the past. So hopefully the other lawyer had these policies and procedures when he deposed the cops, so he knew what to ask them to see if they violated that. So it's kind of, it's kind of a little bit behind and late for this, but he wants them. He doesn't have them at this point. That's the first motion. And this was as of a couple hours ago, so maybe something has changed, but we're going to go through all the ones I saw here. The next one is motion to appoint crime scene reconstructionist and death investigator. The defendant is charged with second-degree M and previously has been found indigent. The undersigned attorney is privately retained. So here we go. Not pro bono, but privately retained, and requests the assistance of a crime scene reconstructionist / death investigator to assist in the defense. The defendant is financially unable to hire a due process provider, crime scene reconstructionist death investigator, to aid in the preparation of the defense, and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. The defense requests the court appoint Dr. Michael Birkland, a crime scene reconstructionist death investigator, for the defendant. Mr. Birkland is requesting to be paid in other court-appointed and has been paid in other court-appointed cases a rate of $200 per hour to perform his duties, included time spent traveling. Undersigned request Dr. Birkland be appointed at a rate of $200 an hour with a initial cap of $6,000 exclusive of necessary costs allowed by statute. Seems reasonable. This is smart. This is good lawyering, in my opinion. You don't ask for $10,000, $1,000 an hour. You ask for somebody very reasonable. You say they've been approved in other cases. You need this to move quickly. The judge said JAC needs to be involved in this. So this is why this is going to happen at a future hearing. It wasn't just able to be handled at the judge at, one, two, three, bang, bang, bang. We're done. Bada bang, bada bang. So we're going to get JAC involved. This is a good indication. $6,000 is reasonable. $200 an hour is reasonable. It's been approved in other cases in Florida. Most likely this will be allowed as long as the judge finds this material, which at this point it looks and seems like it is. Now, what will he get out of this investigator? I don't know. I assume he's going to look through the pictures, going to look through the autopsy, going to take the crime scene photos, reconstruct it, figure out what happened. How did he pass? How did he get into the suitcase? How did it get down the stairs? Was it upside down? Was there a zipper open? I don't know. But a lot of those questions are something an expert can dig into. Will the state object? Do they not know about this? Do they not have a counter expert? Will they need more time? Will we have deadlines extended? Those are questions I don't know. All right, next. A similar motion here. Motion to appoint forensic psychologist. The defendant is charged second-degree M and has previously been found indigent. By the way, they're saying this because even though she is paying him and he is retained, we know she's actually not paying him, and it's not like she came into a bunch of money and can now afford to pay for all these costs and experts and things like that. Attorney is privately retained, but requests assistance for a forensic psychologist to aid in the defense. Financially, Sarah Boone's unable to hire this person. The defense requests the court appoint Julie Harper, forensic psychologist. Harper is requesting what she's been paid in other cases, $200 per hour, to perform her duties, including time spent traveling. And again, they want $7,500 as an initial cap for her, $200 an hour, all reasonable in my opinion and estimation. And if they say no and they create delays or they've got to go find somebody else, I really can't imagine the court doing that after he's denied the continuance. So from my perspective, these two motions, very reasonable. Actually, first three motions, the discovery to give them the policies and procedures, I would say, yeah, turn it over and turn it over quick. You can't have 20 days. You got 5 days. CJ said, Peter, did you see the court TV link I sent here before the live lawyer was a guest? So CJ, my guess is you joined late. The first maybe 20 or 30 minutes of the episode, we broke down that interview in its entirety. So check that out. Frocky said, Peter must be a great lawyer. If I pay by the hour, I want the one who talks as fast as possible. So 99% of my cases are not hourly. They're contingency fee based. The better we do in the case, the more money I get, the more money I get, the more money the client gets, more money the client gets, more money I get. We're all on the same team. Rising tide lifts all boats. That's how I like it. I like to produce. I don't like to clock in, clock out, check in, check out. I would feel bad. I would feel like, oh no, I wasted this time. I got to cut this hour. I love contingency fee based stuff because we're all working towards the same goal. but I appreciate the comment. All right, let's get to the last one here that we're going to talk about today. And this is the one that got the most questions because I think it's probably something maybe a little unusual that you don't see as often. Langer said she will pay him by giving him a book or movie rights. I don't know. I don't know what their financial agreement is. Jen said, can you talk like that forever? Highly doubtful, but probably for longer than you'd expect. All right, motion for a statement of particulars. Comes now the defendant by and through undersigned attorney under Rule 3.140N, Florida Rules of Criminal Procedure, and requests this court to enter an order requiring the state to furnish the defendant with a statement of particulars concerning the alleged offense, including the following. Defendant Sarah Boone has been charged by way of information with a single count of second-degree M. The pertinent part of the information states, charges that Sarah Boone, on or about the 23rd day of February 2020, in said county and state did in violation of Florida Statute 782.042 by an act imminently dangerous to another and evincing a depraved mind, regardless of human life, did kill George Torres. So again, this is the depraved heart killing. That's how we get the second degree in this case. The Florida Standard Jury Instruction for Criminal Cases 7.4M second degree states, to prove the crime of second degree M, the state must prove the following three elements beyond a reasonable doubt: that the victim is dead, the death was caused by the criminal act of the defendant, there was an unlawful killing of victim by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Definitions. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and two, is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. So this is what they have to prove by the acts. Putting somebody in a suitcase, passing out, leaving them there, maybe not, pushed down the stairs, flipped it, whatever, maybe not, unzipped it partially so he can get out himself or place to breathe. We don't know how all those details are going to come out in trial, but this is what they need to prove. This is what it looks like broken down. In order to convict of second degree M, it is not necessary for the state to prove that the defendant had an intent to cause the death. That's the depraved heart, not intentional homicide, but doing something that's so evil or depraved or so reasonably likely to hurt somebody or kill somebody that you do it because you have an indifference for their life, and just a depraved heart, depraved mind. Under Florida Rule of Criminal Procedure, a defendant has the right to know of the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rules require the information on which the defendant is to be tried shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. The information fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. So what does this mean, right? Because this is basically what the rule says you get. What we call these normally as criminal defense lawyers is date, time, and place. So we need the specific date, time, and place. So if we look at the information, it says on or about the 23rd day of February 2020. Okay, so that's the date. Where's the time? Do they want to, is the judge going to make them give a more specific time? Sometimes they do, sometimes they don't. In said county and state, do they want to say at this address? We know where it was. We saw the videos. We saw the suitcase. We know how all that went, but do they want a specific address? Do they want a specific city? Sometimes the judge will make them get more particular about those things, therefore, statement of particulars. Sometimes defense lawyers ask for what they're saying here, a statement with the essential facts constituting the offense charged. So when you read this, how much detail do they want about what Sarah Boone did? Did she push him down the stairs? Did she lock him in a suitcase? Did she zip it up? Was it accidental? Did George get in the suitcase himself? Where are those additional facts? We need those so that we can prepare our defense, is what he is saying. So from my perspective, this is a reasonable ask, and I think the judge will at least tell them they have to give some more particulars. Now, maybe he left out some of the information. I don't have the whole information here to read it. Maybe some of it is on there. But usually judges will allow defense attorneys to get enough information so they can appropriately prepare their defense. That's all the statement of particulars is. It's a very simple motion. It's not a big deal. Very rarely does something huge come out of it. What's really annoying is when we file this early in cases, they give us date, time, and place, and then right before trial, they change that date, time, or place, and the judge is like, well, state attorneys are allowed to do that. They're the prosecutors. They have the burden of proof, and it's like, can screw up our whole case. We've taken all these depositions, done all this work with this specific date, time, and place in mind, and now you've changed it to a month later, or you've spanned it over 2 months, multiple acts, things like that can be very frustrating, but simple explanation for this is usually date, time, and place. And if it's not sufficient, the judge will usually grant it and ask or force the state attorney to provide it. Okay. So that gets us all caught up with the motions that have been filed by her new lawyer, how he's getting paid, and not one, but 2 interviews because we waited from yesterday. You guys got the last video to 10,000 likes like that, which is why we jumped right in and did this. So if you guys wouldn't mind, hit that like button. Let's get this one to 10,000 likes as well, because we're following this case. We're all in. We've got another cool thing coming up with some different perspectives on this case in a couple weeks. So keep an eye out for that. Make sure you're subscribed so you don't miss out on that. Azam said, I like that Peter speaks fast, keeps me awake at 4 a.m. Yeah, I like to keep it moving. I don't want to bore you guys. You sit here. I like to squeeze as much into an hour as I can, just because I think you guys deserve it. I'm not going to sit here and waste time. I want to have it go boom, 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 answer as many questions as I can, like I often love to do. All right. That's all we got for this one. Let me know if anything else comes out. I don't know what we're going to do a video on tomorrow, which is like most days. So let me know if you guys find something. If something interesting pops up, I'd love to look at it, love to break it down with you. Maybe we'll do Hannah Gutierrez's plea agreement. If you guys are interested in that, let me know in the comments. Let me know on Twitter, on Instagram, wherever we can connect. Please let me know. But that's all we got. I appreciate you so much for joining me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.